like to thank my Lord the Chief Justice for giving me the opportunity to write for the bench. First delineated the scope of the reference from the reference in the scope of the reference is therefore limited to A, whether K. Manjusri lays down the correct law, and B, whether the rules of the game, qua method, and manner of making selection can be changed or altered after commencement of the recruitment process. We discussed the above issues. The scope of the reference is therefore limited
following
to A,
segments.
whether K. Manjusri lays down the
One,
correct law,
when the
and B,
recruitment
whether the
process
rules of the
commences
game,
and
qua
comes to an
method,
end,
and
the
manner
basis of the
making
doctrine
selection
that
can
rules
be
of the game
changed
must
or
not be
altered
changed
after
during the course of the
commencement
game or after the
recruitment
game is
process.
played, then whether the decision in
discussed
K.
the above
Manjusri is at
issues
variance with earlier precedents
in
on the subject,
following
whether the
segments.
above doctrine applies with equal strictness
One,
to a method
when the
or procedure
recruitment
for
process
selection
commences and
as
comes
it
to an
does
end,
qua
the
eligibility
basis of the
criteria,
doctrine that rules of the
where the
game must
procedure
not
for
be
selection
changed during the
stipulated
course of
by
the game
or
or
rules
after the game
framed
is played,
either under the proviso
then
to
whether
Article
the decision
309
K.
of the
Manjusri
Constitution
is at
or a
variance
statute
with
could be
earlier
given a go
precedents
by,
on the subject,
and
whether the above doctrine
appointment
applies with equal
could be denied
strictness
by
to a
change
method
in the
or
eligibility
procedure for
criteria
selection
after the game is played,
as it does
qua eligibility
as far as the
criteria.
basis of the doctrine is
Where the
concerned,
procedure
we
for
rely
selection stipulated by
on
Act
our
or rules
earlier
framed
judgment
either
in
under the
Sivanand
proviso to
CT.
Article 309
So
of the
far as
Constitution or a statute
the
could be given a go by,
correctness of Manjusri is concerned,
and whether
we examined the
appointment could be
facts of
denied
that
by
case as
change
also
in the
the
eligibility
case
criteria after
of
the game is
Subhash
played.
Chandra Marwa. As far as the
And
basis
we
of the doctrine is concerned, we relied on
Yeah.
our earlier judgment in Sivanand CT. So far as the correctness of Manjusri is
On the
concerned,
other hand, in K.
we
Manjusri, the
examined the
eligibility
facts of that
criteria
case
for
as also
placement
the
in the
case
select list was challenged
of Subhash
after
Chandra
interviews
Marwa.
were held which had a material
And
bearing
we
on the select list. Thus, Subhash Chandra Marwa dealt with the right to be appointed from the select list, whereas K. Manjusri dealt with the right. On the other hand, in K. Manjusri, the eligibility criteria for placement in the select list was challenged after interviews were held which had a material bearing on the select list. Thus, Subhash Chandra Marwa dealt with the right to be appointed from the select list, whereas K. Manjusri dealt with the right to be placed in the select list.
Thus,
The
further,
two cases, therefore,
what is clear from the
deal with
above
altogether
is that the
different
object
issues.
of any
For the
process of
foregoing
selection
reasons,
for
in our
entry
view,
into public
K.
service
Manjusri could
is
not
to
have been
ensure that a
doubted for
person
having
more
failed to
suitable for the
consider
post is
K.
selected.
Subhash Chandra Marwa.
What is suitable for one post may not be for the other. Thus, a degree of discretion is necessary to be left to the employer to devise its method. Thus, further, to select a candidate
What is
most
clear
suitable
from
for
the
the
above
post
is
albeit
that the
subject
object of
to
any
the
process of
overarching
selection
principles
for entry
enshrined
into
in
public
Articles
service
14 and 16 of
is
the
to ensure that a
Constitution,
person
as
more
also
suitable
the
for the
rules
post is
slash
selected.
statute
What
governing
is
service and
suitable for one
reservation.
post may not be
Thus,
for
in
the
our
other.
view, the
Thus, a
appointing
degree of
authority
discretion
is
slash
necessary to be
recruiting
left to the
authority
employer
slash
to
competent
devise its
authority
method.
in absence
To select a candidate most suitable for the post, albeit subject to the overarching principles enshrined in Articles 14 and 16 of the Constitution, as also the rules slash statute governing service and reservation. Thus, in our view, the appointing authority slash recruiting authority slash competent authority, in absence of rules to the contrary, can devise a procedure for selection of a candidate suitable to the post, and while doing so, it may also set benchmarks for different stages of the recruitment process, including written examination and interview. However, if any such benchmark is set, the same should be stipulated before the commencement of the recruitment process. But if the extant rules or the advertisement inviting applications empower the competent authority to set benchmarks at different stages of the recruitment process, then such benchmarks may be set any time before that stage is reached, so that neither the candidate nor the evaluator slash examiner slash interviewer is taken by surprise. The decision in K. Manjusri does not proscribe setting of benchmarks for various stages of the recruitment process, but mandates that it should not be set after the stage is over. In other words, after the game has already been played. This view is in consonance with the rule against arbitrariness enshrined in Article 14 of the Constitution and meets the legitimate expectation of the candidates, as also the requirement of transparency in recruitment to public services, and thereby obviates malpractices in preparation of select list. Then we examined whether it applies with equal strictness to steps for selection, and we cited few instances such as shortlisting and other evaluation instances. And then we considered whether the rule can be given a go by. And in this, we relied upon the judgment in Sivanandan CT, as also which was followed by a 3-judge bench in Salam Samarjit Singh. And finally, we considered whether appointment may be denied even after placement in the select list, where we relied on Shankarasan Das. So the final conclusions are as follows. The recruitment process commences from the issuance of the advertisement calling for applications and ends with filling up of vacancies. Eligibility criteria for being placed in the select list notified at the commencement of the recruitment process cannot be changed midway through the recruitment process unless the extent rules so permit or the advertisement which is not contrary to the extent rules so permit. If such change is permissible under the extent rules or the advertisement, the change would have to meet the requirement of Article 14 of the Constitution and satisfy the test of non-arbitrariness. The decision in K. Manjushree lays down good law and is not in conflict with the decision in Subhash Chandra Marwa. Subhash Chandra Marwa deals with the right to be appointed from the select list, whereas K. Manjushree deals with the right to be placed in the select list. The two cases therefore deal with altogether different issues. Recruiting bodies subject to the extent rules may devise appropriate procedure for bringing the recruitment process to its logical end, provided the procedure so adopted is transparent, non-discriminatory, non-arbitrary, and has a rational nexus to the object sought to be achieved. Extent rules having statutory force are binding on the recruiting body, both in terms of procedure and eligibility. However, where the rules are non-existent or silent, administrative instructions may fill in the gaps. Placement in the select list gives no indefeasible right to appointment. The state or its instrumentality for bona fide reasons may choose not to fill up the vacancies. However, if vacancies exist, the state or its instrumentality cannot arbitrarily deny appointment to a person within the zone of consideration in the select list. Let the appeals be placed before the appropriate bench for decision in terms of the answers rendered above, after obtaining administrative directions from Honorable Chief Justice.
The
Thank you very much for all your assistance.